Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. Members of the jury, we have resolved some preliminary matters which we need to take up out of your presence, and so that is the reason for the delay. I want to take a few minutes at this time to tell you something about your duties as jurors and to give you some preliminary instructions. As you know, this is a civil case and the attorneys and parties represented here were introduced to you yesterday. The first step in this trial after I give you the preliminary instructions will be the opening statements. The plaintiff will make an opening statement about what evidence he believes he will be able to present to you in support of his contentions in this case. The defendant will then be given an opportunity to make an opening statement about the evidence the defendant plans to put before you. The defense could, if they desired to do so, reserve their opening statement until a later point in the trial. After the opening statements, the plaintiff will present evidence. The plaintiff contends it will support the plaintiff's case. The plaintiff's evidence will consist of testimony of witnesses as well as exhibits and other documentary evidence. After the plaintiff has offered his evidence, then the defendant will offer the evidence which the defendant contends will support the defendant's case. After the defendant has offered its evidence, then the plaintiff may offer what is known as rebuttal evidence. The defendant may also offer rebuttal evidence. After all of the evidence has been concluded, each side will be given an opportunity to make closing arguments, which are sometimes called summations. The arguments of the attorneys, the closing arguments, as well as the opening statements are not evidence. They are only the opinions of the lawyers about what the evidence will be or what the evidence has shown in the case. So while you are not to consider them as evidence, you should pay close attention to it. After the lawyers complete their arguments, I will then give you the instructions of the court. After hearing my instructions, you will then retire to the jury room to deliberate and reach a decision in this case. Your deliberations will be secret. You will never have to reveal to anyone any matter concerning your verdict. You're not obligated to explain it to anyone or discuss it with anyone. Now let me take a minute to explain to you your job as jurors and the role of the attorneys and the judge in this case. As I just told you, I will give you the court's instructions after the evidence and arguments are completed, and you must follow the law as I explain it to you. It would be a violation of your sworn duty to use your own opinion as to what the law is or what it ought to be in reaching your decision. You must follow the law as I explain it to you. Now I'm going to give you the plaintiff's and the defendant's respective contentions in this case. You will recall that this is a case brought under the Americans with Disabilities Act. The defendant hired a clerk in his Sherman facility on February 4, 1995. The plaintiff maintains that he fully and completely performed all of his clerk duties during his employment by the defendant. On or about December the 4th, 2005, the plaintiff was diagnosed with multiple sclerosis, otherwise known as MS. In March of 2001, the plaintiff's physician, Dr. J. Michael Densine, allegedly notified defendant, however, that the plaintiff was fully capable of performing in his clerk position. The plaintiff contends that the defendant thereafter removed him from his position as a clerk and reassigned him to heavy duty in a windshield assembly position for several hours, but was unable to perform the essential functions of the job due to numbness in his limbs. And on March 30, 2003, Dr. J. Michael Densine notified the defendant that the plaintiff could not do the repetitive work being required of him by the defendant in the windshield assembly position, but that the plaintiff could fully perform the clerk position he formerly held. The plaintiff contends he requested the defendant accommodate his physical impairment by allowing him to return to his job as a clerk or to any clerk or light duty status work as allegedly recommended by Dr. Densine, but the defendant refused his request for same or light duty status, and the defendant refused to offer any alternative reasonable accommodations that would allow the plaintiff to return to work. The plaintiff contends that the defendant was treated differently because of his disability. The plaintiff further contends that the defendant acted with malice or with reckless indifference to the plaintiff's federally protected rights. All right, now for some literary material. This is called My Cinderella Story. Ready? Here we go. When I was a student just starting to learn my theory, I was given a writer that I'm sure most of you have written on at some point or another. It was dark green with an old pull-out metal tray. The tripod was made out of steel, and the whole thing weighed a ton. Part of me thought that this was just some hazing prank that I had to go through to get the nicer writers, but no, this was what I and the rest of my classmates were stuck with. While I was progressing through my theory classes, I fell in love with court reporting and developed a love-hate relationship with my writer, which I nicknamed the avocado. For the sake of this story, I wish I would have nicknamed it the pumpkin. While everyone was upgrading to the newest and best models, I was still inking my ribbon and reading from paper and dreaming of the day when I could write on those magical paperless models. I would tell my boyfriend how much I dreamed for the newest and greatest electric paperless student writer and how sick I was of typing up my paper notes on a computer. I was so beyond the archaic methods of the past and yearned for the efficiency of the future. A few years went by and I found myself plodding away in my first speed building class. I came home from a productive day at school to find an envelope on my bed. I didn't order anything, so you can imagine I was surprised to see my name written on the package. Dan, my boyfriend, told me to open it. Inside, I found the student version of the CAT software I wanted inside. I squealed with excitement, but in my head, I was thinking, he is a computer programmer. Didn't he know that I use a manual writer? Still, he was being so sweet. I was so thankful and overjoyed. I promised him that I would start learning all the bells and whistles right away, so when I was able to afford an electronic writer, I could start using it with ease. He looked at me with confusion as though he didn't even think about my writer, then acted confused and upset that he made such a rookie mistake. I've got to tell you that when I'm well into my golden years, I think I will be able to remember those next few minutes with perfect clarity. He then went into the closet and pulled out a much larger box. My eyes widened, my heart was racing, and I had to sit on our bed due to shock. He let go of the package and it plopped in front of me on the bed. He then handed me a pair of scissors. "Open it," he told me. As I examined and opened the box, I started seeing familiar logos on the package and leaflets promoting the company's newest professional writer. At the time, I just thought they were advertising their newest and best to the lowly student, but then I was able to see it. I was receiving the full-blown professional writer. I screamed as loud as a teenager in a boy band stadium. As a tech nerd, I secretly had my heart set on this particular model when I graduated school, but now I was holding it in my hands, bright, shiny, and new. I felt like I was given the keys to a Formula One car and was told to go racing. To top it all off, Dan then explained what he called my school to know which theory I was using so that he was able to pick the correct keypad setup for my writer. After I got everything working the way I wanted it to, I was passing tests and flying through the next few levels faster than I ever thought I could. I never thought in a million years that I would have a fairy tale moment like this. I got to experience the joy of seeing my pumpkin, in this case the avocado, turn into a sleek, brilliant steno chariot, all thanks to my boyfriend. It gives me great pleasure to inform you that 7 years later I graduated court reporting school, passed my tests, got my California state license, and celebrated my second wedding anniversary with Dan. I feel comfortable saying that he and I are both living happily ever after. Let's see, back to some jury charge practice. And let's try this land description. Ready? Here we go. The owner's names and the description of the land and properties which will be benefited or damaged by the construction of said lateral tile ditch are as follows, to wit: Joseph Dickens, southeast 1/4, northwest 1/4, section 19, township 113, range 40, northeast 1/4, northwest 1/4, section 19, township 113, range 40. Bruce Hanson, northwest 1/4, southwest 1/4, section 19, township 113, range 40. Inez Lee, northeast 1/4, southwest 1/4, section 19, township 113, range 40. Mary Aldrich, northwest 1/4, northwest 1/4, section 30, township 113, range 40. Northeast 1/4, northeast 1/4, section 25, township 113, range 41. Arthur and Josephine Beckwith, northwest 1/4, southwest 1/4, section 30, township 113, range 40. Orville and Marie Anderson, northeast 1/4, southeast 1/4, section 24, township 113, range 41. Henry J. Snyder, northwest 1/4, northeast 1/4, section 25, township 113, range 41. Hector Loomis, southwest 1/4, northeast 1/4, section 25, township 113, range 41. Let's try this jury charge. The subject is furnishing necessaries to wife. Excuse me. Ready? Here we go. Ladies and gentlemen of the jury, it is the law of this state that a man, when he enters into the marriage relation, takes upon himself the duty of supplying his wife with necessaries, and if through his own fault he does not, the wife, by reason of the marriage relation, has the implied authority as his agent to procure such necessaries, and the husband is responsible for what is so supplied. If the husband refuses to furnish necessaries to his wife, she may source them elsewhere, and he is liable under the law therefor. However, one who sells goods to a wife can recover from the husband only upon proof that the husband authorized the purchase, or that he refused or neglected to provide a suitable support for his wife, and that the goods sold were in fact necessaries. The term necessaries in this regard is not limited to articles of food and clothing required to preserve life or personal decency, but includes such articles of utility or ornament as are suitable to maintain the wife according to her husband's station in life. Now the plaintiff claims that the goods furnished were for necessaries and that same have not been paid for. When a person renders services or furnishes money or goods to another with the latter's knowledge and consent, the law presumes that the person for whom such services were performed or goods and money furnished intends to pay for the same. When a person claims that such goods and money were furnished voluntarily, the burden of proof rests upon such person to prove by a preponderance of the evidence that such goods and money were furnished without expectations of compensation, or that the same were not to be paid for. And even though there was no contract of sale, the presumption is that payment was intended. Knowledge to the wife in this case would be knowledge to the husband if the transactions with the plaintiff were for necessaries of life, inasmuch as the wife is, by implication of law, the agent of the husband in procuring necessaries for herself. The plaintiff cannot recover in this case except for the funeral expenses, which are admitted because he expected to be paid for the goods and monies furnished by him. So if you find he gave these alleged necessaries to defendant's wife and expected no compensation therefor, then he cannot recover except the funeral expenses. The burden of proof rests upon the plaintiff in this case to prove by the preponderance of the evidence what goods and money he actually furnished to the defendant's wife, and what such goods and money were necessaries for said wife and used by her as such, and what the value of said goods and money was, and what the defendant failed to supply necessaries to his wife. If you find that the goods and money so furnished were necessaries, and that defendant failed to suitably provide for his wife, the amount you find to be the value of the goods and money so furnished will be the amount that the plaintiff will be entitled to recover in this case, unless you find under the rules given you that the plaintiff did not expect compensation therefor. To briefly sum up the issues, if you find under the rules given you from the evidence that the plaintiff furnished necessaries to the defendant's wife as claimed by him, and that such necessaries were not furnished gratuitously, and that defendant failed to suitably provide for his wife, then you will find a verdict in plaintiff's favor for the amount you find him entitled to. On the other hand, if you find that plaintiff did not furnish necessaries to the defendant's wife, or you find defendant suitably provided for her support, or you find the evidence equally balanced or preponderating in defendant's favor on these questions, or you find from the preponderance of the evidence that the plaintiff did furnish necessaries, but that such necessaries were furnished without expectation of compensation therefor, then you will find that plaintiff is entitled to no compensation except with respect to the funeral expenses, which amount to $3,000 and which the defendant admits he is liable for. In any event, you will find a verdict in plaintiff's favor for not less than $3,000. All right, back to some literary practice. This is called Great Expectations. Ready? Here we go. When embarking on the adventures found in court reporting school, everyone comes in with their own set of great expectations. In my almost 20 years of teaching and the 4 years of being a student myself, I have heard many people set goals. Here are just a few of the great expectations I have heard. I am going to finish in a year. I am not going to be the 90% that drop out. I want to make a better life for my children. I want to teach court reporting. I want to set my own hours and work when I want to. I want to be able to work from anywhere. Recently, my students and I watched a YouTube video titled, Will Smith shares his secrets of success. In the video, he says being realistic is the most common road to mediocrity. As court reporters in training, many people try to convince you that you need to be realistic about this profession. They may say, "Isn't this a dying profession? Aren't you going to be replaced by tapes, video, electronic recording, or voice recognition? When are you going to be done with school?" I have even had students tell me that they have had teachers in the past who insinuated that they didn't have what it takes to be successful in this field. One of my great expectations for my students is to believe that they have great careers waiting for them, but it is incumbent upon the student to put in the time and focus and passion that it will take for them to become successful. The field of court reporting is populated by a unique breed of people. They are people who made a decision to become one of a small group of people who can learn a new language that sounds like English when you speak it, but looks like steno when you read it. This new language has to be written at astounding speeds. These individuals can understand people who have accents from around the world, who use parts of speech that are unique to other fields and languages, who have speech impediments or physical disabilities that require machines to help them speak. As students, I would ask that you set great expectations for yourselves. Find that reason that you signed up for a class in court reporting, dust it off, and set it up on the highest shelf alongside your other trophies in life. Practice what you don't know with an intensity built on a desire to be the best in your field. Don't accept others' opinions or limitations on what you can or should be, and most of all, don't be mediocre in your own expectations of yourself. All right, and that will conclude our literary and jury charge practice.